Welcome everyone to Barclay Damon's. Mike, should I let them know it's award winning? What do you think? Award winning.
What award did we win?
Well, it's back here, Mike. We've won two of them. But in all seriousness, dear listeners, Rosemary Enright, Mike Sciatti, your fearless co-host here. I'm in Buffalo. He's in Syracuse, and we're so glad you're joining us for yet another episode of our labor and employment podcast. It's a beautiful day here in Buffalo. A lot of our recordings in the past were done in the winter, so lots of cold and snow and ice, and it's gorgeous here today. So how is that in Syracuse, Mike?
I am in Oswego at my house, and it is gorgeous and hot.
There you go. Perfect. That's right. I forgot you're in Oswego. So today we are joined by one of our esteemed colleagues, Rob Thorpe. Rob, you want to take a moment and just introduce yourself?
Yeah, sure. Hello, all. Thanks for having me. Been on the podcast once before, so sort of know the drill. My primary practice is in labor and employment. Also do some commercial litigation. I am maybe 15 years out. Feels like 30, 50. I don't know. Feels like a long time. But what we're going to talk today about is website accessibility, which has become a huge part of my practice. A problem in many respects, but a huge part of my practice. And I think it'll be educational for employers who happen to be businesses.
Yeah. Great. Well, we're so happy that you agreed to join us, Rob, because I do know how busy you are. But before we jump in, Rob, Mike and I always like to start every episode with a question. All right. And just so everybody gets to know a little bit about us. So
Sure.
The question for this episode, and all three of us will give an answer. The question for this episode is, what has given you joy in the past week?
Okay. The
All right.
thing that has given me the most joy this past week is the thing that gives me the most joy and perhaps stress every week, which is my little man, my 9-year-old Walker. Quite the handful, but he's my monster, so love him. But this week, he had a lacrosse game on Monday, and he played great. 4 goals. I think he had 3 assists. But the highlight for me was when I see the little man come up. He'll sneak me a wave or sneak me a smile. He was dancing at midfield over who knows whatever's going on in his mind. But those moments where I see that he's still a kid, even though he's on the path to unfortunately being much older.
Yeah, that's great. That's great. I love it. Well, and I love that he sneaks you a wave here and there. That would bring me joy too.
Yeah, he just goes like this on the sideline.
That's awesome. That's awesome. Well, and congratulations to Walker. I love Walker stories. So
You've heard a lot of them.
yes, I have. So Mike, what about you? So joy in the past week.
The joy was, it looks like we have clearance and we're going to be closing on our new house next week. Thank God, finally.
Yes.
It's been like a never-ending drama over it, but I think the end is in sight, and then we're in there.
That's awesome. Congratulations. And Rob, so you know, I've told Mike he's got to have a party and have us all there.
We will.
Yeah. So looking forward to that.
Yeah, and it needs a little work, so it'll be more like Labor Day because we bought it out of foreclosure. But everyone's been chomping at the bit wanting to get in there, and it's just, oh my God, so slow these people are.
Yeah. Well, good. I'm glad that it's coming along. Well, my little bit of joy, I've had a lot of joy, but I think the most joy was I had hurt my ankle about a month ago. And so I haven't been able to really get out and walk or hike or do any of those types of things that I like to do. And so this weekend on Sunday, I was able to go to Rhinestone Woods, which is a local here in Western New York, beautiful local reserve, and was able to do a 3-mile walk, which was terrific. And so that brought me joy. But what added to it was a gorgeous day. You're through the woods, come around a turn, and there's a lake, and there were hundreds, and I mean hundreds of lily pads, and the flowers on them were the color of like watermelon, that color. And I mean, as far as and they had not opened, so they were all up. So it was just this beautiful lake, not moving, and just all of these magnificent flowers across it. And it was breathtaking. And I stopped and just took 2 minutes to be in the moment and completely, bliss, peace, everything. So that was my joy for the past week.
Good for you.
Yeah, yeah. So, and I'm just pleased that my ankle's coming along. So, all right. Well, enough of the fun stuff. Let's jump right in. So, Mike, if you don't mind, I'll kick it off. I know you've probably got a bunch of questions too for Rob, but Rob, the first question I'm sure all of our listeners, if they've stayed with us, please do, listen to our story, and then they're like, website accessibility, whatever, has nothing to do with me. So, it is an L&E podcast, Rob. So, why would we talk about website accessibility? Why do our listeners care about this or need to care about it?
Yeah. Well, any business with one employee is an employer, and any business with a website is at risk of being targeted in one of these website accessibility lawsuits we're going to talk about. There are 50 plus firms in the United States, each of which has multiple, sometimes dozens of, we'll call them serial plaintiffs, plaintiffs that file one lawsuit after another against businesses in a variety of different industries. It could be business that sells products on the website, business that offers services, businesses that just use the website to provide information to the public. They're all at risk of being targeted in one of these lawsuits. And I mean, it's been going on for a decade, but I'd say the last few years, the uptick has been substantial. I mean, there's hundreds filed a day and nobody's safe.
Wow, that's crazy. So does that mean, Rob, so for example, Barclay Damon, we've got our website with, all of our attorneys listed and that. So are we at risk?
Yeah, you could have a plaintiff visit the website, claim they wanted to read Mike Schiotti's profile, but our website wasn't compatible with their screen reader, and therefore they were denied access to information that would allow them to select a law firm. I will say, good news for us is law firms aren't really being targeted
Yeah.
in these.
Of course, now they will because we said that.
I know.
We've just put it out there. But in all seriousness, so that means, we work with, as the small mom and pop pizza place who has a website where you can order, your food through and have DoorDash deliver it, up to, national and multinational. And so literally, and I'm just making this point, correct me if I'm wrong, Ron, but literally pizza place that's got, 3 or 4 employees and you're just using it to order, they're at risk, just like I'll just use my former employer, Oracle, who's in, 150 countries and everything in between, right?
Exactly right. I mean, I've defended a pizza joint. Because you give that example, I've defended a company that manufactures and sells barbecue sauces, a company that sells custom made jewelry. I mean, there are hotels or the plaintiff, there's one in particular, Deborah Lawfer. She stopped filing lawsuits, but she was up over 600, went all the way up to the Supreme Court. But these weren't hotels. She admitted she was a tester. She didn't plan to visit the hotels. She claimed that she went to the website for the hotel and it didn't provide her enough information about, for example, the accessible rooms, the width of the doorway for wheelchairs, a grab bar in the bathroom. So it can just be an informational deficiency that triggers a tester to sue a business.
Interesting. So it isn't just necessarily the accessibility to the actual website itself, but it's, as you just said, also informational. That's interesting. I didn't realize that, Rob.
Yeah.
Wow.
I mean, those were probably 5 years ago. Those were hot. With the
Yeah.
Deborah Lawfer situation, it kind of quieted down, and now it's mostly e-commerce. So you sell a widget. I went to the website, my screen reader, whether it was a screen reader or whether it was a website that wasn't accessible, I could not complete the purchase for that widget. And rather than calling the company or sending an email, it's yet another lawsuit.
Hey, Rob, could you sort of explain to the listeners the disabilities these plaintiffs have, and when they go to the website, what they can or what they cannot do, I guess, would be the concern.
Yeah, most of what we're talking about are visually impaired individuals. I mean, there are some lawsuits by hearing impaired, but for the blind or visually impaired, they use screen reading software like JAWS, for example. And so they visit a website, and it literally it dictates back whatever they're scrolling on to describe the earring or the barbecue sauce or whatever the product is, to describe the price. And so the screen reader is capturing all the information on the website and in audio format back to the visually impaired person.
And then as a follow-up, have you run into situations where they've gone after employers because a job applicant could not access the application materials on an employer's website?
I have not, but you just probably triggered a new trend. with that question. No, we've certainly dealt with, the three of us have dealt with sort of pre-hire accommodation type issues. That's not one that I've personally dealt with. And I'm not seeing it in the broader context of these website lawsuits.
And it is, though, arguably something a potential plaintiff could bring a case for. I was not able to apply for the job because the employer's website was not in compliance. Is that
Yeah,
fair?
I completely agree. I compare it to, I won't use names, but the individuals who have prior criminal convictions that are kind of combing the job ads. And if there's anything that says don't apply if you have a criminal conviction, they may likely were not interested in actually getting that job, but they're interested in filing a complaint with the Division of Human Rights or the EEOC.
Yeah, and that made me just think of this. Tell me what the two of you think of this. So yes, I can't apply. I can't read the application. What about the job description or the job post that has requirements that talks about the physical requirements and that does not comply with what the ADA has said is permissible to include in a job description? Could that fall under this? Could they go out and someone go out and say, hey, listen, I went and read this job post and this violates the ADA. When you look at it, it says I have to be able to stand or something like that.
Yeah,
What are your thoughts on that, Rob?
from my perspective, I mean, that's going to trigger kind of the applicant pre-hire interactive process. You need an accommodation to fulfill one or more of these job duties listed on the description of the posting. That's where you're going back and forth to see whether we accommodate it. But you're right. If the job description is blatantly discriminatory, it's going to be a problem. But
Yeah.
there's usually, in my experience, going to be a discussion with the applicant as to what the restrictions are and whether we can accommodate them.
Yeah. Okay. All right. Oh, so I'm sorry, Mike, were you going to ask something?
So I was just going to say let's say employers and businesses have a website. How would a employer know if they are or are not in compliance?
It's the key question, the threshold question. Part of the problem, and keep in mind, listeners, that I'm coming at it from a defense lawyer's perspective. So I'm not saying every plaintiff out there hasn't been wronged or doesn't have a claim. The ADA was passed in 1990. And at that time, Congress wasn't contemplating websites, let alone website accessibility. You fast forward 36 years, and the Department of Justice still hasn't issued regulations under Title III of the ADA to govern what standard applies. What's the technical standard businesses, employers should be using to make the website accessible? So I think, again, from a defense lawyer's perspective, that's the ambiguity in the law that's really being exploited here, because what the heck does it mean to be accessible if you don't have a law setting the standard? Like they do for commercial facilities. Business owners know you're going to construct a new building. You got to comply with the ADA architectural guidelines. You're going to make substantial alterations to an existing building. There's code, there's guidelines to follow. It's just not the same in the website space. There's international standards like the Web Content Accessibility Guidelines, but that's what the plaintiffs are demanding. It's not what the law requires. At the same time, if you don't do anything, you're subjecting yourself to one of these lawsuits. So it behooves businesses to take steps to remediate the website to make it as most accessible as possible.
Right. And what does that look like? What does that mean, Rob?
Yeah. So
And
most
I
of
know
my,
you're not a website designer, but you're handling these cases and you put in a defense in that. So what should they do?
yeah, most of my clients, if they're not, I mean, some are sophisticated. They have an in-house IT web development team, and they go through the coding and make the website accessible. I mean, line by line, item by item. Others retain third-party consultants. And these lawsuits have sort of created this industry, not just for plaintiffs and for defense lawyers, but for ADA website consultants.
Wow.
So
What they
Rob,
do, Rosemary, I have no idea what they do
Yeah.
on the back end. They're just
Yeah.
so
not tech savvy enough to know.
when you hire the consultant, and I know we've run into this, you and I, they usually have you execute a contract with the employer. And a lot of times counsel's not brought in on that contract. They sort of just sign it and say, okay, you're doing this for us. But employers really have to pay attention to those contracts with the consultants fixing their websites for, like, are there disclaimers? Are there indemnification provisions? things like that. Could you sort of just explain the importance of that document the employer enters into with a consultant to fix their website?
Yeah. 5 years ago, 10 years ago, I mean, again, I wasn't thinking about website accessibility. Businesses certainly weren't thinking about it. But contracts as of late, it's almost necessary that you know what you're getting and what you're paying for. And ADA, if there's a website consultant or vendor out there that doesn't know about these lawsuits, that's a problem. And so the contracts at a minimum should have an agreement representation that they're going to make the website ADA compliant, substantially conform to the WCAG standards, something. And I said at a minimum, at the best case scenario, you're going to get a defense and indemnification provision. If you make changes to my website, you say it's ADA compliant, whatever that means, and me, the business owner, is subsequently sued as in one of these cases, you better step in my shoes, defend the work you did, and indemnify me if you got it wrong.
Yeah, and I'll add one thing to Rob's comment. I agree with everything. Rob and I ran into this once where the indemnification clause required notice within like 5 days of the lawsuit or something ridiculous being filed. So you really need to pay attention if you get a demand letter or a lawsuit, if you have one of these consultant agreements, to really make sure you know what it says and to get that request for indemnification in front of them in the time required under the agreement.
Yeah.
Yeah.
There are very few. I mean, I deal with a lot of website vendors, and I understand why they don't want to include a defense indemnification. A lot
Yeah.
of times they don't mean they might do the initial product, or project, whatever that is, but a business adds a new SKU, a new product, a new service. Like the vendor doesn't have control over that. So we, the business, is making changes, and now we're caught in a lawsuit. The website vendor is going to say, well, you did that. We set you up to be successful, but changes you made impacted the analysis, which is why I think periodic monthly monitoring, audit scans of the website. That way you can address accessibility issues as they arise in real time.
Yes, and I think that's a great point, Rob, because you don't realize constantly updating, like even the nonprofits we work with, they add new services. So they add a new page to their website. So you're right. And having come from Oracle, you know that you make this change or you add this, there's going to be a chain, there's a whole chain of events that happens, and this may not be connected to that, and all of a sudden this isn't accessible and the other is. So I think that's a great suggestion for our listeners, which is a monthly audit, and I think probably once you get a baseline, that initial audit is probably going to be significant, right? It's going to take a lot of time and an effort. You get everything where it in theory needs to be, whatever that is. And then from there, you're then just checking maybe these things that you've added or updated along the way. So
Yeah. And there's two reasons to take it seriously. One is you want to broaden your customer base. Any
yes,
business does. And
yeah,
the second is you want to avoid being the target of a lawsuit. I mean,
right,
there's a reason to make the investment and
yeah.
to do the monthly monitoring or
Yeah.
quarterly monitoring, whatever you're going to
Yeah.
do.
And the third I'd say is, let's be honest, I don't think anybody listening right now is thinking, well, I don't want it to be accessible. I don't want to prevent someone who genuinely is hearing impaired or visually impaired. I don't want them to lose the opportunity, to access our website, the services we have or the products we have. So I'd add that as a third. So
I've never had defended 300 more of these cases, which says less about me than the sheer volume of lawsuits being filed.
yeah,
I've never had a client say, well, I don't want a disabled person to access my website to
precisely.
purchase a product. I mean, it's the complete opposite. So,
That's right.
from their perspective, being accused of discrimination, it really is the opposite. I mean,
Right.
they didn't know the person they don't know the person at all, but
Yeah.
they certainly didn't want to deny him access.
Exactly. Exactly.
And,
So,
and, and Rob, when these cases are sued, what damages are they looking for from the employer or company? And then, sort of as a corollary, have you seen insurance coverage for employers on these type of cases?
Yeah. So there are no damages under Title III of the ADA. It is attorney's fees and injunctive relief. And it's the attorney's fees, which courts have recognized that's what's driving this litigation. And so it's the plaintiff may claim they were harmed and may have been harmed by the experience on the website. but there's no damages going to the plaintiff or to the plaintiff's law firm. It is attorney's fees and injunctive relief. On the insurance coverage side, again, all those cases, I can count on one hand the number of times their insurance kicked in to provide coverage. And even when they have, it's usually under a strained reading of a EPLI, private practices liability policy. A client recently asked me, is there separate insurance coverage solely for these types of claims? There may be.
Yeah. And related, Rob, so just tell, could you explain to us how these are sued? So I'm the pizza place that you represented. Like how does this even start? So just take us through the process.
Yeah, the business usually has no idea that this is even in the works. More recently, some of these firms have started to send demand letters. They'll give you 30 days, fix your website and give us money. I mean, that's the gist of the letter. But the lawsuits filed, they're filed all over the country. I mean, I'm defending them in Massachusetts and Illinois, obviously in New York, Indiana, Wisconsin. I got admitted in those two jurisdictions because of these lawsuits. So they start with the lawsuit, and typically before a business is even served, they hear about the lawsuit from not me, but from other defense lawyers who are out kind of soliciting this type of work, or from website vendors. So they must be trolling the court dockets and saying, aha, here's a new website case. The business finds out about that there's a complaint filed. A lot of businesses say this is a scam, like we all fear being caught up in some scam.
Right.
And so they maybe ignore it, or they reach out to their counsel to say, is this legit? After that happens, the business will eventually be served. And once they're served, federal court, you'll have 21 days to respond.
And just take us through. So they've got the 21 days to respond. So let's say that one of our clients, got hit with one of these website accessibility, and you step in to assist them. So what happens at that point? So think about like when somebody with a DHR complaint and it's new to them, what happens? And we explain to them, well, this is the process and this is where we're going and where, we hope to land. So
starting with it, you have the 21 days to respond. Maybe you didn't reach out to me, wait until there's 4 days left. We're going to get an extension. But the next step, the aspect of the discussion is, one, is any remediation required? What do you know about website accessibility? What have you done? The other aspect of the conversation is, what do you want to do? There are 3 options. There's settle, there's you file a motion to dismiss, or you file an answer and proceed with discovery. And every business has a different reaction. Some just say, make this thing go away. I don't want to be caught up in any litigation. Some say, we've been monitoring the website for years. We take this very seriously. It's offensive that we'd even be accused of this. It's a matter of principle, and we're going to fight it. And we're going to either fight it with a motion, or we're going to fight it with an answer and proceed with discovery.
Rob, you said some of these plaintiffs are what I call frequent filers. They file lots of lawsuits. Have you had any success with the argument that basically says, hey, look, they are not serious. They were not going to go to a hotel in downtown Syracuse. They had no intention of actually doing it, and therefore they don't really have standing to bring a lawsuit. Has there been any success in that?
Yeah, I'd say that's been the leading defense for the last few years. Where we've seen courts dismiss cases is based on lack of standing. The plaintiff is a serial filer with no interest. Again, I'm not saying all plaintiffs. I'm just generally speaking. Serial filer with no interest in the product or service they substitute throughout their dozens of boilerplate complaints. They had no interest or intent to return to the website. They filed the lawsuit for the point of extracting a settlement rather than any genuine interest in the product or service. So standing has been a huge defense. Another one has been that the website in and of itself is not a place of public accommodation. If you look at the ADA, again, passed in 1990, it lists all these build restaurants and hotels and amusement parks. There's nothing about websites. And so a standalone website, say for an e-commerce business, not connected to any physical structure, the argument is that's not a place of public accommodation. A third would be mootness. It's another subject matter jurisdiction defense. We remedied any alleged deficiencies on the website. The website's fully accessible, and therefore your claims are moot. You're seeking injunctive relief. A court can't grant injunctive relief on claims that are moot. There's no case or controversy for the court to decide. And so, again, that's why I think it's important for all the reasons we said, but from a defense perspective, to take steps to make sure the website's accessible.
And Rob, let's say you have a website. It is not accessible to someone who is either visually or hearing impaired, whatever the case may be, and you hire the consultant to actually fix it. How long do they really need, generally, in your experience, to make it in compliance? Is this a quick and easy fix, or is this something that might take a few months?
It goes back to the issue of what is compliance. And so what standard are we chasing? There are AI overlays, widgets. A number of companies offer these Accessibility, UserWay, AudioEye. You search website accessibility in Google, and it's going to be those three that pop up. Whether they work or not, I mean, those companies obviously say they do, but it's a widget you see on some websites, a stick figure you see off to the bottom right or left-hand corner, and you can click on it and increase the font size, change the color. Some have screen reader components. Those are cheap. They're popular for that reason. But I'm also seeing businesses who have those widgets, it seems like they're being targeted. And it's not a knock at the product. They may very well work. But there was a New York Times article a couple of years ago that the takeaway was that those AI overlays widgets often do more harm than good. I don't know how that's possible, but that was the gist of the article. One of these AI widget companies was fined by the FTC last year for $1 million for misrepresenting that the widget makes the website accessible. And now there's a class action lawsuit pending against one of those companies. So that's the widget side of things, which scares the heck out of me.
Yeah.
Again, they may work very well, and I'm sure those companies maintain that they do. But it doesn't help when you're then hit with a lawsuit. You're back in the same spot. And of course, they're not going to defend and indemnify you.
Right.
There are alternatives. There's a company, UsableNet, for example, that are much more expensive, at least the quotes I've seen, but they do agree defend and indemnify the business if they're subsequently hit with a website accessibility lawsuit. And then there's some options in the middle. So I think it's important for employers, for businesses, as you're evaluating this, to explore many options, because there are reputable vendors out there. I'd say as far as timeline, there's a company I work with often out of Cleveland, Ohio. They're called 216 Digital. 7 to 10 days to get in and out. It's not bulletproof. It's never going to be, but that's a pretty quick turnaround. I think the companies like UsableNet that do a manual remediation over phases in a period of time could be several months. The widgets, on the other hand, takes about an hour.
Yeah. You get what you pay. Well, again, I'm sure I won't say anything. We'll stop there with that comment. But in the interest of time, Rob, we try to keep these to 30 minutes. So, and generally Mike and I might at the end say, all right, here's your call to action and your next steps. If you had to, tell our listeners, relative to website accessibility, what should they, when they finish listening to this, what would you advise they do?
Yeah, I would take an hour right after this, or at your convenience, I suppose, reading about it, reading about the cases, reading about website accessibility, possible vendors, exploring with your IT team, with your website vendor. What's the status of our website? Run an audit, run a scan. There's free ones online. Purchase the software like our firm did for the defense of these cases to see what the plaintiffs are saying. What issues do we have that we need to fix? So I think step one is become knowledgeable and work with your IT department or an outside consultant to see what you might need to do to make the website compliant. The alternative is, I was going to say, if you're hit with one of these lawsuits, what do you do? The first step, and any lawyer is going to say this, but consult with your attorney. Find an attorney who's experienced in this subject area. It's not every solo practitioner out there. In fact, a few attorneys are dealing in this space of website accessibility. It's kind of a niche area. So find an attorney who's experienced. It doesn't have to be me. It doesn't have to be Barclay Damon, but find somebody who knows what they're talking about, because if you're not practicing in this landscape, you're not in the know. You have to know the plaintiffs. You have to know the law firms to get the best result for the client. Step two, after hit with a lawsuit, goes to what I just said, conduct your own audit or work with your vendor to conduct an audit of the website and remediate any of the deficiencies that are alleged in the lawsuit. Step three is going to be go back to your counsel and come up with your plan. What do you want to do here? Do you want to settle and make this go away? Do you want to fight because this is important to you? It's a matter of principle. And explore those options. And then I think the last step is what I mentioned before, the constant monitoring. Make sure you're not going to again, you want to address issues monthly, quarterly, annually. Make sure you're staying on top of accessibility issues as they arise and promptly remediate them if there's new issues.
That's awesome, Rob. Wow. I mean, that's just
So
great.
a lot to digest. I probably
No,
scared
but
away some listeners.
no, not at all. But I mean, and Mike, I think you'd agree. I mean, Rob, you just made it so crystal clear. Boom, boom, boom. I mean, that's why people listen. They want, what is our call to action? What should we be doing? So that is awesome. Thank you, Mike. I think you wanted to add something.
And Rob, I think you have written some legal alerts on this, and that people listening to this can go to our website and just grab those and read them.
Yeah, of course. I mean, I write one a month probably on the topic.
Yeah. Yeah. All right. Well, great. Well, Rob, thank you so much for joining us. This has been awesome and very informative. As always, we love learning and hearing about these, the different matters that our colleagues are handling. So thank you for that.
You are
And
very welcome. Thanks for having me.
of course, and before we sign off, everyone, and I have to read it because it's the first time that we're going to be letting you all know this, but we're going to ask that all of you mark your calendars. So Barclay Damon's 2026 Labor and Employment Law Conference, also known as our symposium, is coming up. So we've got it scheduled. Mike and I are working on it right now. It is scheduled for Thursday, October 29th at Turning Stone Resort Casino in Verona, New York. You can join us. It's a day-long event. We're going to cover, hot topics, things that, we've talked about for years, but everybody still struggles with. There'll be a keynote. We'll be, letting you all know who that'll be in the coming months. But we hope that you'll join us. Again, that's October 29th at Turning Stone in Verona, New York. And with that, I think we'll wrap it up. Remember, as we always say, you can listen to us on Spotify, YouTube, and all those other cool places. And we'll catch you on the next episode. Mike, you want to add anything?
That is absolutely a perfect conclusion. Nothing to add other than I would question your initial characterization of Rob Thorpe as esteemed.
Yeah. I thought they would come back to bite me.
Yes, exactly. So, all right. Thanks, guys. We'll see you soon.
Have a good weekend. Take care.
Hey, thanks.
Bye-bye. The Labor and Employment Podcast is available on barclaydamon.com, Spotify, and all major podcast platforms. Be sure to like, follow, and stay connected for future episodes.